Long Island Audit released a copy of the Cop-Tuah 911 phone call, and it showed former Sergeant Brian Fahey to be exactly as much of a psychopath as we all knew him to be. The story of the legally ignorant and arrogant Kentucky prosecutor who sued the local police department for failing to provide him with a blue light escort gets a little more interesting. And our story about Natasha Lopez, the victim of the warrantless home invasion in Woodstock, Georgia, is starting to gain traction, all on this week's episode of The Rebuttal. What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer, and this is The Rebuttal, where we do updates and clarifications to videos that we've done generally the week before, but sometimes, if need be, we'll talk about videos that we've done a little bit in the past, which is why we're talking about Cop-Tuah once again. As an initial housekeeping matter, if you haven't seen the original videos from the stories that I'm going to tell today, feel free to pause the video here. All of the links to the original stories will be in the video description. You'll be able to go back, watch each of those videos, and come back and finish this video so that you'll be up to speed. The first matter on our docket this morning is the insanity of the Cop-Tuah 911 call. Keep in mind that one of the most difficult things to prove in a criminal case is always what is referred to in the law as mens rea. It refers to a person's state of mind. And generally what we use to try to prove a person's state of mind is what they did, not necessarily what they said. You can usually, use some sort of circumstantial evidence or something that they did, some behavior that they had to say, well, this is why he did this. And then what you're trying to do is persuade the jury, because a lot of times you just don't have any statements that the person made that would give you like a clear-cut understanding of what was going on in their mind. Well, as you might expect, being that Brian Fahey has no clear understanding of the law or how they would prove a case against him. In fact, his ego and arrogance would have never allowed him to even contemplate a scenario where he'd be charged criminally for this. He clearly was just going to say whatever was on his mind, and that probably won't be detrimental to him, but it would be to anybody else, right? So if you haven't had an opportunity to see it yet, Sean Paul has posted a copy of the Cop-Tuah 911 call, and in it, you can hear Brian Fahey's wife screaming for him not to go, and he tells the dispatcher, I have a gun in my hand, and I'm going to go shoot him right now. And again, you can hear his wife saying, Brian, no, and all this stuff, but keep in mind, that is absolute intent. That is what would be a absolute gift wrap piece of evidence as far as premeditation if we were dealing with a homicide. And what was really interesting about the way that Sean Paul posted the video was that he was able to sync it up so that you could see where Fahey was proximally to the residence when he's making all these statements. And so Fahey actually gets the gun and gets back outside to where Sean Paul is. By that time, they're well outside of the curtilage and well outside of the protections of the castle doctrine at that point. And the 911 call does really two things. It proves that Fahey's reckless and threatening state of mind was not about protecting anyone. It was about retribution. And I would argue that had he shot and killed Sean Paul, this evidence would be all that the state would need to prove premeditation. Well, that's not really true. In order to prove premeditation, the state would first need a thing that it's never going to have, and that would be a motivation to actually seek justice, right? And that's what we call a threshold issue in the law. Remember, we talk about it all the time that you can't get to point B without first getting to point A. So because the state's attorney seemingly has no motivation to actually hold Fahey accountable for his actions, and furthermore, no respect for the public, it seems like State Attorney Fahey has been completely content with just sweeping this under the rug, probably in hopes that the public would never hear that call. Well, the public records request got you, my dude, and now I hope you have a good explanation for why you only charged him with disorderly conduct when you knew what his mindset was all along. This is a perfect piece of evidence to prove all of the charges that I discussed in my original video. Again, if you haven't seen it, there'll be a link in the description. And it's not lost on me that the reason people call Connecticut Corrupticate is for stuff like this. You have a perfectly gift-wrapped piece of evidence as to what a person's state of mind was, what their intention was, what they were trying to accomplish, and all of that right there on a 911 call that until last week when Sean Paul put it out, you were the only person that knew it existed. And you could have easily had this case charged so that when the FOIA request inevitably produced the 911 call, you could look pretty good saying, well, look, this was the evidence. This is what we charged. This is what happened. Okay. Objective truth. You wouldn't have had any heat from the public, but now you're still trying to pin these criminal charges and felony charges on Sean Paul Reyes when you've done virtually nothing to Brian Fahey. And I hope and pray that your political career suffers as a result of your ineptitude and your inability to impartially prosecute the people who manifest themselves as criminals in your state. Anyway, I digress. Next on the docket is the absolutely astonishing case out of Williamsburg, Kentucky, where the local assistant prosecutor sued Williamsburg police because they failed to stop what they were doing, which was running calls for service, and meet him in the city so that they could give him a blue light escort to the hospital after his wife severely cut her hand and was bleeding from an artery. Now, this story is much more wild than I knew when I reported it after seeing the news story. And I'm going to be doing a lot more in-depth follow-up story because I have a lot of people giving me a lot of information that's really going to be a problem out there. But here are a few things that I can now report that I didn't know then. Again, I'm saving a lot of what I know for the big update, right? And we'll do a whole separate video about it. But one thing for sure that will never change in a small town is that people talk. And seemingly, the second this video hit the airways, I started getting emails from people in that area, people who work in the courts, people who work in the government, wanting to give me the missing details about all of the context that I've missed out on by this short 2-minute video from the news station. Again, if you're not familiar with the backstory, the original video is in the description, but essentially the assistant prosecutor sued the police for not meeting him and giving him an escort to the hospital. His wife had cut her hand, and right after the story published, I actually got an emailed copy of the lawsuit complaint that he filed. And it amazes me that he found a lawyer to file this suit. But here's the thing that's even more mind-blowing than what we knew before. Joshua Price and his wife do not even live within the city limits of Williamsburg. He lives outside the city, in the county. So imagine that you have a self-inflicted injury, and you jump in the car, and you drive to yourself to a city where it didn't happen, and then you get mad because the traffic is moving slowly, and you call 911 to get a cop to come and meet you and run blue lights so that you can speed without consequence. That's all this is, and nobody even denies that that's what the issue is. But you're suing the city, which under relevant case law for decades has no duty privately to you, and the injury did not even occur within their jurisdiction. And I mentioned in my previous video that Joshua Price, the way he talked to a dispatcher, sounded like he was formerly in law enforcement. He identifies himself in the complaint for the lawsuit as a former Whitley County deputy. So that my hunch was correct as it relates to that. But what's worse than the conduct of Joshua Price? And remember, he said that if his wife would have died, they'd have had themselves a postal moment, essentially making it obvious that he felt like he would have been compelled to shoot a place up over some perceived entitlement to something that he actually doesn't have an entitlement to. But what's worse than that is that Ronnie Bowling, who is the elected Commonwealth attorney, and I've gotten this from multiple people, indicates that his office will no longer allow police officers to have body cams in their office. His prosecutors will no longer allow conversations with police officers to discuss cases if they have a body cam recording, and he basically is going anti-body cam. Now, Ronnie Bowling was just recently elected, I'll put a little screenshot, by his peers to be the president of the Kentucky Commonwealth Attorneys Association. In Tennessee, we have a District Attorneys General's Conference. This is basically, I think, the same thing. They call them Commonwealth attorneys in Kentucky. But that means that not only is he representing his own district in his attempt to kill transparency, but he is also helping shape policy throughout the entire state. And his stance, and he literally said that the primary purpose for this action was to protect his prosecutors. So, Kentucky has a statute governing the use of body cams and how they're supposed to be used once an agency actually equips their officers with body cams. And his directives are completely antithetical to the spirit of the law, and they're antithetical to the legislative intent. And this is the guy who is the president of all the prosecuting attorneys in the state of Kentucky. And my guess is they don't know he's doing this. So I'm going to be leaning on a couple contacts that I have in the AG's office in Kentucky, and I'm going to be poking around and digging around to try to figure out what, if anything, the Commonwealth's Attorney Association knows about his efforts to stifle transparency in his own jurisdiction. My guess is that they're not going to love that. And, you know, the whole thing is that he's framing this prosecutor as if he's a victim. And I tell my kids this all the time. And sometimes I even have to say it to myself because, you know, I have periods where I act like a child too. But if someone is saying something about you that you don't like, the very first thing on your sort of personal responsibility flow chart that you should consult is whether the thing they're saying about you is the truth. If it's not the truth, then obviously you have a reason to be upset. But a lot of times it is the truth. And you just don't like the way it makes you feel. And I tell my children, and I tell myself, and I tell my wife that if you don't like the way it feels when the truth lands on you, you're the only person who can change the truth. You can change your behavior to be something that you would be proud of if people found out about it. Because ultimately, that's what we have here. We have a situation where a guy said something he's not proud of that caused him problems. And as a result, the answer has been, well, we need to get rid of anything that might document what happens and is objectively true. So that way we don't have to lend ourselves to objective facts then and make decisions. It's insane. And I think the most important thing to consider here is that, Mr. Bowling, no one has done anything to your prosecutors. In fact, this entire incident from top to bottom was self-inflicted. It was, in fact, Mrs. Price who injured herself. It was Mr. Price who got the sole vote as it relates to the language he would use to describe his feelings in court. It was him who showed up to a city that he doesn't live in, demanding services that he's not entitled to, and then suing the police for not giving it to them when he has no legal or ethical entitlement to it. And it was ultimately him who drew everybody's attention to this entire matter by filing a lawsuit. So how do you protect a prosecutor who cannot get out of their own way and is the source of all of their problems? You can't do it. What you need to be doing is protecting the people who voted you in, because those are the people that you actually owe a duty to, not your prosecutors who can't seem to stop stepping on their own dicks. And I think the thing that is most disturbing about this is that keep in mind that Whitley County and McQuarrie County are border counties to Laurel County. Laurel County is where London is. And London is where Doug Harless was asleep in his bed and was shot by multiple police officers who broke into his house. And they broke in because they say they had a search warrant, but they also say that the search warrant was for a house that he didn't live at. So they came into the wrong house and shot him dead as he was trying to sleep and was awakened by their unlawful entry. Okay? They said they had a search warrant. Nobody can seem to find this search warrant. It's not on record anywhere as far as I've been able to find. And to beat it all, London didn't have body cams. And the city council didn't even know that, right? And then we found out later, well, London didn't have body cams because they made a decision that it was too expensive. Okay? So what you're saying, Ronnie Bowling, is that you could see no value for having an objective witness that would objectively and without bias report to you the facts of a situation that became as drastic as the one in London, Kentucky. And that is a county neighboring and touching both of the places where you prosecute cases on behalf of the Commonwealth. And somehow it is lost on you what the value of independent evidence from a police officer's body cam could be. Mr. Bowling, I need to make this very clear, and I hope that you see this. This story is getting ready to explode, and you'd be wise to fix it your way before I have time to fix it my way, because we're not going to stop talking about this, and people aren't going to stop learning about it, and it's time for you to do the right thing and stop being silly. Now, on to the final matter on our docket, and that is Natasha Lopez, who, if you don't remember, was the victim of a warrantless home invasion in Woodstock, Georgia, by Cherokee County deputies earlier this month. She's currently trying to decide on a civil rights attorney to take her 1983 case. But before she can really do anything with the 1983 case, she has to be able to take care of these criminal charges. And if you don't remember, she was charged for obstruction for simply telling the police officer that he couldn't enter her home without a warrant and trying to block his ability to enter her home without a warrant. At present, she is forced to use the services of a court-appointed attorney, and she would like to be able to raise some money to hire a lawyer so that she'll find somebody who will actually fight for her case. And so if you've seen my channel, I've never put up somebody's GoFundMe page, but I have featured her story. And so I'm going to ask you guys, because I've had a bunch of you either privately email me or write in the comments that you'd like to be able to donate to help her legal defense. So I'm going to leave a link in the description to her GoFundMe page. No amount is too small, and she's probably honestly going to need about $10,000 to hire a decent attorney who will fight for the dismissal of these charges. I'm still planning to release my long form follow-up and my interview with her, but I just wanted to throw it out there because, you know, it's getting to be about kids shopping 30, and before y'all start dropping all your coin on these shit-ass kids for Christmases and all of that, I wanted to put it on your radar. Maybe we can get, you know, $5 out of you or whatever. No amount is too small. It goes a long way. She really needs the help. Anyway, those are the updates for the week. I hope you guys are enjoying the rebuttal. I'm really enjoying doing it every week. It's a great way to just give you sort of micro details that weren't available at the time. I'm also writing companion blogs over on Substack. That's a newsletter site where you can come. It's absolutely free and join the community. You can join on a paid tier if you want to, but that's only for people who want to support the channel monetarily. I don't put anything on Substack that people have to pay for. In addition to Substack, we've also started a Facebook page. I brought my son on over as the social media and brand manager, and so you guys will be getting introduced to him very soon. You should be able to find the Southern Draw Law official Facebook page. We're going to be putting the link to that in the description as well. If you guys would please do so, follow over there. It helps a lot with the algorithm and introducing our videos to different audiences that haven't seen them yet. If you don't want to go to Facebook and you don't want to join Substack, but you'd like to support the channel monetarily, I'll leave my Venmo and PayPal links both here on the screen as well as in the description. And I just want to mention that I have about a 1 million person monthly recurring audience, but only about 120,000 of you guys have actually subscribed. It costs you nothing. I beg of you, please subscribe. It helps tremendously with the algorithm because every person who's subscribed is a new person that gets a notification when I put out a new video. So I don't expect anybody to pay me money. I do this for free. I do it because I love it. But if you could, it don't cost you anything. Please hit the subscribe button and sign up so that you get notified for the videos. Check out some of the other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.